So, this is a continuation of the previous episode with respect to company law problems and solution. So, this is the part 2 of company law problems and solution. So, here the first topic we are going to discuss is on perpetual succession. During a war, all the members of a private company while in general meeting are killed by a bomb. Does the company cease to exist because all the members die? State reasons. So, the solution here, Meat Supplies Guildford Limited 1966. So that is a case law. Here, Meat Supplies Guildford Limited 1966. An incorporated company never dies. A company has a perpetual succession. Its existence is in no way affected by death of all its members. Members may come and go, but the company will go on forever. In the above case, during the war, all the members of a private company, while in the general meeting, were killed by a bomb. The court held the company survived. The existence of a company can be determined only by law. Being an artificial person, it cannot die irrespective of the fact that its members, even the founders or subscribers to memorandum, may die or go out of it. So, another problem with respect to perpetual succession, ABC Private Limited company is a private company having 5 members only. All the members of the company were going by car to Mumbai in relation to some business. An accident took place and all of them died. Answer with reasons under the Companies Act 2013 whether the existence of the company has also come to an end. Here, the existence of the company does not come to an end. We can use the same case law as in Meat Supplies Guildford Limited. The nominees or legal representative of the deceased members shall become the new members of the company. Now, the next topic is illegal association. So, the United Traders Association was constituted by 2 joint Hindu families consisting of 51 major and 5 minor members. The association was carrying the business of trading as retailers with the object for acquisitions of gain. The association was not registered as a company under the Companies Act or other law. State whether Union Traders Association is having a legal status. Will there be any change in the status of this association if the members of the United Traders Association is subsequently reduced to 45? Now, with respect to this case, United Traders Association is an illegal association since the number of adult members exceeds 50. So, since the number of adult members exceed 50, it is an illegal association. Effect of subsequent reduction in the number of members would not make any change in the status of the United Traders Association since an illegal association continues to be an illegal association even though subsequently the number of members is reduced below 50. So, this is an important point. An illegal association continues to be an illegal association even though subsequently the number of members is reduced to 50. Now, illegal association is discussed in section 464. Illegal association is discussed in section 464 of the Companies Act 2013. It provides that no association or partnership consisting of more than 50 persons shall be formed for the purpose of carrying on any business that has for its object the acquisition of gain by the association or partnership or by individual members thereof, unless it is registered as company under this act or is formed under any other law for the time being in force. If such an association is formed and not registered under either the Companies Act or any other law, it will be regarded as an illegal association, although none of the objects for which they may have been formed is illegal. In order to attract the prohibition contained in section 464, the following conditions must be fulfilled. The first one, it must be a company, association or partnership consisting of more than the specified number of persons. So, if the association has members more than 50, that is adult members more than 50, then it becomes a illegal association. Now, the second condition, it must not have been registered as a company under the Companies Act, nor must it have been formed in pursuance of some other Indian law. Now, the third condition, association or partnership must have been formed for the purpose of carrying on any business. And the fourth condition, that the business must have for its object the acquisition of gain by the company, association or partnership or by the individual members thereof. Now the non-applicability. The prohibition contained in section 464 shall not apply to a Hindu undivided family carrying on any business or an association of partnership if it is formed by professionals who are governed by special acts. Now, with respect to section 3 capital A, here the problem is a public limited company has only 7 shareholders, all the shares being fully paid. All the shares of one such shareholder are sold by the court in an auction and purchased by another shareholder. The company continues to carry on business thereafter. Discuss the abilities of shareholders of the company under the Companies Act 2013. So we have to discuss the liabilities of the shareholders. So section 3 capital A is the relevant section here. The remaining 6 members are personally liable for debts of the company. So it is discussed that if the number of directors go less than the minimum required as per the act, and if it continues beyond 6 months, then the people becomes all the directors becomes personally liable for the debt occurred or incurred. Now, with respect to section 3 capital A, if at any time the number of members of a company is reduced, in the case of a public company below 7, in the case of a private company below 2, and the company carries on business for more than 6 months while the number of members is so reduced, every person who is a member of the company during the time that it so carries on business after those 6 months and is cognizant of the fact that it is carrying on business with less than 7 members or 2 members, as the case may be, shall be severally liable. So they shall be severally liable for the payment of the whole debt of the company contracted during that time and may be severally sued therefore. The members shall be liable only for such of the debts as have been incurred by the company after a period of 6 months. So the next problem we have here is, directors of a public limited company accepted a bill of exchange on behalf of a company, but the word limited was omitted from the name of the company at the time of acceptance. Who can be held liable for the payment of the bill? So here the issue is, the word limited was omitted from the name of the company at the time of acceptance. So who is made liable in this case? So with respect to that, directors may be held personally liable if the company refuses to pay. Liability of the directors is in the nature of the surety's liability. So these all come under section 3 capital A. So when the number of directors is reduced with respect to the minimum limit as prescribed in the law, or when the word limit is excluded, for all these disputes, this relevant section is 3A, because we have to comply with the conditions laid in section 3 capital A of the Companies Act. So in this case, where the word limited was omitted from the name of the company at the time of acceptance of the bill of exchange, here if the company refuses to pay, the liability of directors is in the nature of a surety's liability. So the directors become personally liable. Now another problem here is, Sunrise Limited submitted the documents for incorporation on 5th October 2014. It was incorporated and the certificate of incorporation of the company was issued by the registrar on 20th October 2014. So the application was submitted on 5th October 2014 and it was the certificate was issued by the registrar on 20th October 2014. The company on 14th October 2014, that is before the certificate of incorporation was issued by the registrar, that is on 14th, between the application and the issue of certificate. The company entered into a contract which created its contractual liabilities. The company denies the said liability on the ground that the company is not bound by the contract entered into prior to issuing of the certificate of incorporation. Decide under the provisions of the Companies Act 2013 whether the company can be exempted from the said contractual liability. So, from the date of the certificate issuance only, the company gets a legal personality. So, here the defendants were using this as a ground to be exempted from being liable. So, the solution: a pre-incorporation contract means a contract entered into by the promoters on behalf of a proposed company, that is, before incorporation of a company. These contracts are usually made by the promoters to acquire some property to the right for the proposed company. Now, sometimes contracts are made on behalf of a company even before it is incorporated, but no contract can bind a company before it becomes capable of contracting by incorporation. Two consenting parties are necessary to a contract, whereas the company before the incorporation is a non-entity, and this was discussed in Kellner versus Baxter 1866. So in Kellner versus Baxter, the court held that the pre-incorporation contracts are not binding on the company because for a contract to be valid, it needs consent of both the parties, whereas before the incorporation, there is no legal personality for the company, and thus such a person does not exist, or it is a non-entity, non-existent entity. So it is not binding on the company, and that contract is not valid. So that is held in Kellner versus Baxter 1866. And then it is not that we don't have any remedy with that. As per section 15 and section 19 of Specific Relief Act 1963. So as per section 15 and section 19 of Specific Relief Act 1963, a company as well as other party to the contract is bound by pre-incorporation contract if the following conditions are satisfied. The first condition: the promoters entered into a contract before incorporation of a company. The second one: the contract so entered is for the purpose of the company, that is, the promoters entered into the contract on behalf of the proposed company. And the third condition: such contract is warranted by the terms of incorporation of the company, that is, the contract falls within any of the clauses contained in the object clause. And the fourth condition: the company has accepted such contract after incorporation of the company. The fifth one: the company has communicated such acceptance to other party to the contract. Now, these are the 5 conditions where that needs to be satisfied to apply section 15 and section 19 of the Specific Relief Act 1963. So, with respect to Companies Act 2013, a pre-incorporation contract is not binding on the company, but that doesn't mean that one doesn't have a remedy. He or she can use, any party can use the sections 15 and 19 of Specific Relief Act 1963 if the 5 conditions are met. The 5 conditions are: the promoters entered into a contract before incorporation of company. Then the second one: the contract so entered is for the purpose of the company, that is, the promoters entered into the contract on behalf of the proposed company. Then the third one: such contract is warranted by terms of incorporation of the company, that is, the contract falls within any of the clauses contained in the object clause. The fourth one: the company has accepted such contract after incorporation of the company. And the fifth one is that the company has communicated such acceptance to other party to the contract. So these 5 conditions should be satisfied in order to invoke section 15 and section 19 of the Specific Relief Act 1963. Now, if a company after incorporation enters into a fresh contract in terms of the pre-incorporation contract, the pre-incorporation contract shall stand discharged, and accordingly the liabilities of the promoter shall come to an end. And that was discussed in Howard versus Patent Ivory Manufacturing Company. Howard versus Patent Ivory Manufacturing Company. So 2 case laws were discussed with respect to this, that is pre-incorporation contract of the bindingness of pre-incorporation contract on a company. The first one was Kellner versus Baxter. Here what the court said was, before incorporation of a company, such a legal personality or such an entity does not exist, and contract needs the consent of both the parties for it to be a valid one. So before incorporation, the person itself does not exist, and such a contract cannot be binding. That is in Kellner versus Baxter. Then the second case law we have here is Howard versus Patent Ivory Manufacturing Company. Here what was said is that if there is a pre-incorporation contract and after the incorporation the company executes a new contract for the same effect, then the pre-incorporation contract stands discharged and the liabilities is set forth based on the contract that was made after the incorporation of the company. So that is held in Howard versus Patent Ivory Manufacturing Company. And with respect to Companies Act 2013, it is to be noted that incorporation contracts are not binding on the company. That doesn't mean that there is no remedy. One can invoke the remedy under Section 15 and Section 19 of the Specific Relief Act 1963 if the 5 conditions prescribed are satisfied. So that is with it. And the next problem we have with respect to Section 3 capital A. A company was incorporated on 6th October 2013. The certificate of incorporation of the company was issued by the registrar on 15th October 2013. The company on 10th. Once again, here the date 10th October comes between the application made and the certificate of incorporation. Application was made on 6th of October 2013 and the registrar issued the certificate on 15th October 2013, and the company on 10th October 2013 entered into a contract which created its contractual liability. The company denies the said liability on the ground that the company is not bound by the contract entered into prior to issuing of the certificate of incorporation. Decide under the provisions of the Companies Act 2013 where the company can be exempted from the said liability, said contractual liability. So this is this is exactly the same issue as we discussed just now. So we can use the same case laws, that is of Kellner versus Baxter, then Howard versus Patent Ivory Manufacturing Company, then the remedy under Section 15 and Section 19 of Specific Relief Act 1963 with respect to the 5 conditions under it. Now, pre-incorporation contracts in general are void ab initio and hence not binding on the company. So the word you should use is void ab initio and hence not binding on the company. However, under Section 19 subclause E of the Specific Relief Act 1963, so more specifically Section 19 subclause E of the Specific Relief Act 1963, the party to the contract can enforce the contract against the company if 1. the company had adopted the same after the incorporation, and 2. the contract is warranted by the terms of the incorporation. Unless the company adopts the contract, the other party cannot enforce the same against the company. Promoters can be held personally liable. So that is with respect to the problems under Section 3A, 3 capital A. The first one we discussed was when the number of directors is reduced below the minimum limit as set by the act. Then we discussed about the omission of the word limited when the company entered into the contract, and then we have pre-incorporation contract, whether they are binding or not, whether they the parties have any remedies or not. So these were the problems that was discussed under Section 3 capital A. Now the next is effect of memorandum and articles. So the next problem we are going to discuss is from effect of memorandum and articles. The articles of association of a limited company provided that X shall be the law officer of the company and he shall not be removed except on the ground of the proved misconduct. Now the company removed him even though he was not guilty of misconduct. Decide whether the company's action is valid. So here the relevant section is Section 10 of the Companies Act 2013. Once again, Section 10 of Companies Act 2013. Company's action is valid and X has no remedy against the company. Now, effect of a memorandum and articles. The first one, subject to the provisions of this act, the memorandum and the articles shall, when registered, bind the company and the members thereof to the same extent as if they respectively had been signed by the company and by each member, and contained covenants on its and his part to observe all the provisions of the memorandum and of the articles. So that is the effect of the memorandum. And subclause 2 says that all monies payable by any member to the company under the memorandum or articles shall be a debt due from him to the company. So this is what is discussed with respect to effect of memorandum and articles. And here the relevant section is Section 10, and company's action is valid and Mr. X has no remedy against the company. Now, effect of ultra-virus transaction. So the object clause of Memorandum of Association of the XYZ Private Limited, New Delhi, authorized to do trading in mangoes. The company, however, entered into a partnership with Mr. A and traded in mangoes and incurred liabilities to Mr. A. The company subsequently refused to admit the liability to A on the ground of ultra-virus the company. Now, advise whether stand of the company is legally valid, and if so, give reasons in support of your answer. Once again, we are discussing with respect to Section 10 of Companies Act 2013. The company is not liable to A. The partnership agreement for trading in mangoes is an ultra-virus contract, and the ultra-virus contract is void ab initio and is not binding on the company or the other party. The power to enter into partnership is not an ancillary or incidental power. Such power can be legally exercised by the company only if the object clause of the memorandum expressly authorizes the company to enter into partnership. Ultra means beyond or in excess, and virus means powers. Thus, ultra virus means an act or transaction beyond or in excess of the powers of the company. An act or transaction shall be ultra virus if 1. It is not permitted or authorized by the Companies Act 2013, 2. If it falls outside the object clause of the memorandum, and the third one, if its attainment is not incidental or ancillary to the attainment of the main objects. Now, effects of ultra-virus transaction. An act which is ultra-virus, the company is void and is of, an act which is ultra-virus to the company is void and is of no legal effect. Neither the company nor the other contracting party deserves any right under an ultra-virus contract. Even ratification of an ultra-virus contract by the whole body of shareholders does not make an ultra-virus contract valid or enforceable. So that is with respect to ultra-virus transaction. We have another problem from the ultra-virus transaction, effects of ultra-virus transaction, and that is X, a chemical manufacturing company, distributed 20 lakh to scientific institution for furtherance of scientific education and research. Referring to the provisions of the Companies Act, decide whether the said distribution of money is ultra-virus to the company. Donation of Rs 20 lakh for furtherance of scientific education and research is permissible. So here the donation of 20 lakh for furtherance of scientific education and research is permissible and is not ultra-virus to the company. Now, another problem we have is the object clause of the Memorandum of Association of RST Limited Authorities. It authorizes it to publish and sell textbook for students. The company, however, entered into an agreement with Q to supply 100 laptops worth 5 lakh for resale purpose. Subsequently, the company refused to make payment on the ground that the transaction was ultra-virus to the company. Examine the validity of the company's refusal of payment to Q under the provisions of Companies Act 2013. In terms of Companies Act 2013, the powers of the company are limited to 1. Powers expressly given by the memorandum, which is popularly known as an express power or conferred by the Companies Act 2013 or other statute. And 2. Powers reasonably incidental or necessary to the company's main purpose, termed as the implied powers. The Act further provides that the acts beyond the powers of a company are ultra-virus and void and cannot be ratified even though every member of the company may give his consent. That was discussed in Ashbury Railway Carriage Company versus Rish, 1875. Ashbury Railway Carriage Company versus Rish, 1875. So it is in that case where the court held that for an act that is beyond the powers of the company and are ultra-virus and void and cannot be ratified even though every member of the company may give his consent. That is, every shareholder, everyone gives consent to and ratifies. It cannot be made valid and binding on the company. That was held in Ashbury Railway Carriage Company versus Rish. So the facts of Ashbury Railway Carriage Company versus Rish was the Ashbury Railway Carriage Company was into transportation of goods through railways, and the company issued some loan for the construction or for the support of construction. So construction was not the part of the object clause of the company, that is transportation of goods through railways. So that was held that this act of funding for construction or assisting in assistance in construction work is ultra virus. Though it is for railway, it is ultra virus to the company. It is not incidental or ancillary to the company, and thus it cannot be ratified. So that was the case with Ashbury Railway Carriage Company versus Rish, 1875. The object clause enables shareholders, creditors, or others to know what its powers are and what is the range of its activities and enterprises. The object clause, therefore, is of fundamental importance to the shareholder, creditors, and others. In the given problem, RST Limited is authorized to publish and sell textbook for students. It has no power to enter into an agreement with Q to supply 100 laptop. Such an act never be treated as express or implied power of the company and is not conferred by the Companies Act of 2013 or by any other statute. Q is deemed to be aware of the lack of powers of RST Limited, that is the constructive doctrine of constructive notice. The Q is deemed to be aware of the lack of powers of RST Limited. In the light of above, Q cannot enforce the agreement or liability against RST Limited. Hence, the refusal of the company for the payment to Q is valid. The House of Lords in Ashbury Railway Carriage Company versus Rish, 1875, held that the objectives of a company is mentioned in the object clause of the company's memorandum of association, that is absolute. House of Lords in this case applied the same principle and held that the contract which has been entered into by the company was beyond the scope of the object clause of the memorandum of association of the company. The House of Lords also had that by entering into the concerned contract with the Rish, that is with respect to Ashbury Railway Company and Rish. The House of Lords also held that entering into the consent contract with Rish, the company was in breach of the clause that had been included in the constitution of the company. The clause that were included in the memorandum of association did not allow the company to make a contract. Keeping this in mind, the House of Lords held that the transaction concerned here was invalid and thus consequentially held that the contract shall have no legal effect for the company or the Rish. The judgment resulted in a defeat of Rish to have the contract enforced since there could not be any breach. This was due to the fact that there could not have been any contract to be breached in the first place. Now, a similar problem is those 6 out of 7 signatures to the memorandum of association were forged. The company was registered and the certificate of incorporation was issued. Can the registration of the company be challenged subsequently on the ground of forged signature? So this is also with respect to the effect of memorandum of association and its forged. So here in the case it was held that once the certificate of incorporation is issued, the company gets its legal personality and that certificate is valid. So that is with the part 2 of company law problems and solution. We'll be carrying on with the rest of the problems in the next parts. Thank you.